Good afternoon, everyone. Thank you so much for being here. My name is Kelly Crum, Content Specialist with Maryland Realtors, and I want to welcome you all to our 10 Legal Myths webinar. Today, we have with us Senior Legal Associate Cleo Pappas and our other legal associates, Taylor Kitzmiller and Ting Dong. Together, they will dive into demystifying common legal myths in the real estate industry. We do encourage your questions, and we look forward to answering them. Please post all your questions in the Q&A box below at the bottom of your Zoom screen. This webinar will be recorded and posted on our YouTube page for future reference. And with that, I will turn it over to Cleo. Cleo, take it away.
Thank you so much, Kelly. I appreciate it. Welcome, everybody, to our webinar this afternoon. Thanks for taking out the time. We want to set this up. We get a lot of questions on our legal hotline, and we want to, like Kelly said, demystify some of the things that are out there in the realtor world. So we have 10 legal myths. I am joined by Taylor Kitzmiller and Ting Dong of our legal department, and Laura Fitzgerald, who is our very much appreciated legal assistant. I did want to say a few things before we start on this part of the webinar. I wanted to remind everybody that we do have a legal hotline where you're more than welcome to call in if you have really pending legal questions for us and you need help deciphering what's going on or what you should best do. Those hours are to call in to our phone number Mondays, Wednesdays during the summer, 10 to 12 and 2 to 4, and on Fridays, 10 to 1. Once Labor Day hits, we'll also have Friday hours from 10 to 12 and 2 to 4. We also have other resources for you as well. Our Maryland Realtor website is a great resource for a lot of information. Many of your questions can be answered on there. We also have a specific designation on there for frequently asked questions that we get a lot, and we put them up there so you can have an answer if after hours you don't have a chance to call us. We also have a wonderful YouTube channel, like Kelly mentioned. You can watch previously recorded webinars and other information that we put out there. And I will also mention that we are still having our early bird special going on now for our Ocean City conference in mid-October. So we have lots of CE classes, great speakers scheduled, and we encourage everybody to come down to the beach for a wonderful week and lots of information. And thank you, Laura, for putting up our information for the legal hotline. So we probably can get started now on the next slide. Okay, so myth number one. If some of you know me from practice in previous years, you know I really hate this word. So there is no such thing as a ratified contract. And when I say this, and for everything that we're discussing, we are talking about the Maryland Realtor forms. I know some of the local jurisdictions have different forms and may utilize this wording, but for Maryland Realtors, we do not have this word. There's no word that appears or any variation of it in any of the Maryland Realtor contract documents. Legally, it holds no meaning in the context of a contract between a buyer and seller for real estate in Maryland. And it has led to lots of unnecessary confusion among agents and clients. I will give you an example. Recently, we had a question come through, and the agent asking the question said, how could a seller do this to my buyer? Well, the buyer sent over an offer after having received the disclosure packet from the sellers. On the inclusion-exclusion form, there was an appliance that was not included by the seller, but the buyer wanted it. And the buyer just checked off that appliance, sent over that form with the rest of the offer. The seller and listing agent noticed that the appliance was included, though they knew they had given the document over without that appliance included, and everything else was signed, but the listing agent said, please send back this document with that appliance crossed out. We have already crossed it out, put an initial. And the agent said, but we already had a ratified contract. And before the buyer had a chance to initial and sign, the sellers accepted a different offer. And I had to explain, well, at that point in time, you thought you had a ratified contract, but there was no such thing. You didn't even have a contract because what you sent over was a counter to what the sellers were offering. and the sellers countered again, and you had not yet accepted. Therefore, the buyer was out of luck and the seller had the opportunity to accept another offer. So be really cautious when you're using this term, because it will cause a lot of confusion when you don't understand that an offer plus acceptance plus delivery equals a contract in the state of Maryland regarding real estate. So of course, everything has to be in writing. It's the statute of frauds, but make sure you know when you do or don't have a contract and you're still in the negotiating and counteroffer stages. So like I said, written offer plus written acceptance plus delivery equals a contract, and words do matter. Understand the differences between counteroffers, addendum, disclosures, and if you're not sure, come on and join a contracts class with us. We'd love to have you. I think you can do the next slide, Laura. Thank you. And we're all going to be taking turns, so it's not just myself talking.
So legal myth number 2 is that it's okay to leave items blank on a contract. This is not true because the statute of frauds requires that contract for the sale or rental of real property to be in writing and signed by both parties. Material terms, which include price, settlement date, contingencies, timeframes, inspections, financing inclusions, exclusions, are all necessary components and cannot be left blank. A real-life example is when seller and buyer put TBD as a sales price. And because sales price is a material term, a contract like this is not valid.
All right, I'll take over myth number 3. Myth number 3 is there's a 3-day contract review for new builds and resales. This is something we hear sometimes on the legal hotline and in some of our classes. It seems to be somewhat of a common misconception that agents think that a buyer automatically has this 3-day period after going under contract to terminate and back out of the contract, which is just not the case at all. The only time the buyer may have the right to terminate is if it is specifically stated in the contract. So if there is a, let's say, property inspection addendum that is used that specifically says buyer may have the right to terminate, sure, they may have that right, but there is no just automatic 3-day review period for the buyer where they have a right to terminate. It's only if the contract specifically states that. You can go on to the next one.
Thank you. I'll take that one. So myth number 4, seller keeps EMDs if the deal falls through. So again, words matter. An escrow holder maintains the earnest money deposit for the benefit of both parties, not just the seller, and definitely not just for the buyer. EMD is not automatically awarded to the seller as liquidated damages, even if the buyer is in default. There are legally required steps before the escrow holder can release those funds to either party. The seller has never been in possession of the EMD and has no automatic right to keep it. So please keep in mind that first, escrow, earnest money deposits, are not legally required to form a contract of sale between a buyer and seller for residential property in Maryland. A lot of people include it as a proffer, and if they do, it better be good, but it's not legally required to form a contract. That being said, the word keep is really not in good use, because the escrow holder, whether it's a buyer, brokerage, or a title company, is the one holding those monies, and they can't do anything with it without instruction from both parties as to how it gets dispersed, either at settlement, because that's how it's supposed to be dispersed if everything goes through, or with a mutual release of deposit. And if there's no mutual release of deposit signed by both parties, the escrow holder has a very strict statutory guideline as to what they may or may not do with that deposit. So we do have a form called earnest money deposit, mutual release of earnest money deposit. We have it in our forms library. Hopefully many of you have seen it. And that has the process step by step for any escrow holder. So unfortunately, we hear a lot of times, well, my seller wants to keep it. And there's nothing that can be done that automatically transfers those funds from the escrow holder to the seller. Go to the next slide.
So So legal myth number 5 is that a contract is accepted once signed. This is not true. A contract's acceptance date is actually when the last party signs and delivers the contract and the other party acknowledges receipt. Both parties must agree on the date. The date cannot be pre-filled and must reflect actual delivery and acknowledgement. The last party to receive the fully executed contract, and we're talking about the MAR residential contract of sale, that party should update and share page 11 when acceptance is complete.
All right, myth number 6 here, emails are agreements between buyer and seller. So no, that is not the case. Emails alone are not going to create a binding contract. Sure, you can have negotiations over emails, communication over emails, but in order to have an enforceable contract of sale, it's going to have to be 1, put in writing, and 2, signed by all the parties. Actually, this week, I received a hotline call from an agent representing a buyer, and I won't go through all the details, but essentially, their buyer made an offer, and the seller's agent indicated that the seller was, excited to accept that offer that was made over email. However, there was no actual written contract ever created and signed by all the parties. And eventually that seller ended up accepting a different offer. And that buyer was upset and thought they were under contract because of the seller's agent's email saying, my seller's interested in accepting your offer. That's not the case. The only way you're going to have a enforceable contract of sale is if it is in writing and signed by everybody, and if all the material terms are defined. So make sure, and what I told this buyer's agent was, sure, you can explain to your buyer what the seller's agent said, but let your buyer know we're not under contract until we actually have something in writing and everybody has signed. So don't get super excited until you have that pen to paper.
Number 7. Is that me? So myth number 7, you can represent the
Actually,
buyer.
Cleo, I think this is me.
Oh,
I'll
I'm
take
sorry.
this one. That's my bad.
Sure.
Myth number 7, you can represent the buyer and seller at the same time. No, you cannot. The only way that can happen is if a broker acts as a dual agent. So if that's the case, if you're maybe representing a buyer and a seller says, hey, I would like you to represent me as well, that's not allowed in Maryland. The only way that could happen is through dual agency. So where the broker acts kind of at the top of the pyramid here, acts as the dual agent and will assign an intercompany agent to represent the seller and another agent to represent the buyer. And those agents represent buyer and seller just as if they were a normal buyer and seller, but they have a duty of confidentiality to their client. In other words, the buyer's agent, even if the buyer's agent and the seller's agent work with the same brokerage, that buyer's agent has a duty of confidentiality and can't go talk to that seller's agent about, maybe how much their buyer wants to offer, any confidential information of that buyer. Same goes for the seller. The main thing to know here is in order to have dual agency, you have to get the consent from both parties. So typically, we have our consent for dual agency form. Typically, a buyer or a seller will sign that when they are sitting down with the broker for the first time and consent to that. However, if the situation of dual agency pops up later, the buyer and seller have to reaffirm their consent. The consent for dual agency form is a two-part form. So the client can sign and give consent at the beginning, but then when that actual dual agency situation pops up down the line, they have to go to the second part of the form and sign again, reaffirming that consent.
Number 8, A myth. Pet deposits are illegal. Well, not quite. A fear deposit intended to protect a landlord from damages caused to the property by a pet is considered a security deposit as defined by Maryland law. Effective this past year, October 1, 2024, a landlord may not collect more than 1 month's rent as a security deposit. That is in total. Therefore, any pet fee or deposit must be included in the total security deposit and in an amount not to exceed 1 month's rent. So this causes a bit of confusion because, and again, I was in practice, and in our heads, we are thinking, as my understanding, that most landlords automatically just charge 1 month's rent for security deposit, and they wish to charge additional deposit for any pet. So that's no longer allowed. If there is going to be a pet deposit, it has to be all encompassed within that 1 month's rent. So keep in mind, only 1 month's rent. However, we do get the questions on a legal hotline because landlords are concerned, and a lot of people, and this is truly for pets, want to be able to take their pet with them, and they proffer, well, what if we charge a rent to the pet? That is doable because it's a rent. Pet rents have not been encompassed with the law regarding security deposits as a total of 1 month's rent. And it's my understanding, Taylor, correct me if I'm wrong, but I believe there may be a change to the upcoming lease come October 1 to account for that possibility of rent for pets instead of security deposits. So when you see that form, definitely Taylor has another webinar coming up sometime in September before all the new forms are released for the effect of the new laws on October 1. Make sure you jump on that to get the heads up regarding those new forms and what needs to be included. But we get a lot of pet questions. And again, these are pets. I won't go into the fair housing class that we teach the difference between pets and assistance animals. So make sure you jump on that when you have a chance. Thanks. Take the next one. I think that's mine as well. Thank you. Myth number 9, you still work for your client post-settlement. Your main duties end at settlement. Per your agreement, whether listing or buyer, they end at settlement. Confidentiality is still a duty, and it remains on you unless waived in writing by your client. So that's forever. If you have any post-settlement issues, which I know they pop up, you must go back and talk to your broker, refer your client to your broker. Do not attempt to negotiate for your buyer or seller post-settlement. If something pops up, something breaks, there's an issue, they're upset about something, unfortunately, you may not negotiate post-settlement for any kind of legal or financial damages on behalf of your client. You're not an attorney. Please do not attempt to write, in lieu of repairs for X, seller gives buyer, i.e. the new homeowner, X dollars. That will get you into a heap of trouble and probably will not assist your client in any way. The best practice for you post-settlement is make sure you have all your documentation regarding your client engagement, your contract, and anything else pertaining to that client or that deal, and keep it organized if you are ever asked for it by your broker or from an attorney. So keep in mind, post-settlement, be extremely cautious in trying to advocate afterwards for your client. Last but not least.
So on a related note, legal myth number 10 is that you can write an addenda or cross out forms. Because you're not an attorney, you cannot alter any forms, including crossing out and writing an addenda. Doing so is the unauthorized practice of law, and the Maryland Realtor contracts and forms are copyrighted material. There's actual law that prohibits this and makes this a crime. And potential violations include being fined, being guilty of a misdemeanor, and maybe even imprisonment.
So we went through those myths relatively quickly. Again, these are all things that we see on a very regular basis with the legal hotline. and we hear in classes. We just want to make sure some of the basics are covered again for all of you, because in the heat of deals and issues and working with clients, we know sometimes the devil's in the details, and sometimes we forget certain things, and it's super important to have the basis to go forward and having a good, clean business. So we wanted to make sure these are out. I know I see several questions. Laura, are you okay if I go through some of these?
Yeah, go ahead.
Thank you very much, Tom, for your comment regarding no such thing as ratified contract. I'm going to leave the tenant right of first refusal question for a legal hotline. Please feel free to call in tomorrow and we'll be able to answer that, because it's a little bit more complicated than what we can, give an answer to right here on this webinar. Laura's question is, what if both parties don't sign the EMD release? What should happen then? So again, depending on the reasoning behind why there should be an EMD release, or if somebody's requesting it, that is dictated by the statute and the form. Read it step by step. Speak to your escrow holder as to what then occurs. Sometimes escrow holders, even though they have a right to do something, they sit on it sometimes, and they wait for the parties to try to negotiate it out, and hopefully both parties sign the mutual release of deposit. Sometimes that doesn't happen, and they have to go and follow the rules step by step on the EMD release form. Taylor, do you want to take the next one? As part of an offer contract, can buyer pre-sign an escrow lease from the seller? I'm sorry. Can buyer pre-sign an escrow release form the seller can later use if buyers do not proceed with the contract?
I've actually never heard of that. And Cleo, you can correct me if I'm wrong, but I don't think there's anything that prevents a buyer from pre-signing the release. I'm assuming you're talking about the release of deposit agreement. So I don't think there's anything that prevents it. I can see that making a buyer's offer a little stronger because the seller knows that the buyer's serious if they're willing to give up the EMD. So yeah, I don't see anything wrong with that.
Yeah, I don't see any legal precautions against it, but I would just be quite sure before signing that if I were a buyer.
Yeah.
Let's see. Can you please briefly review when and who signs understanding who agents represent? I keep seeing disclosure packages that have the understanding who form, which says seller understands that their listing agent represents the seller, and then a blank one. So those are no longer required for every party every single time. They are only to be used when an agent meets a potential client and they're not the client yet, or they represent the other side. So they're not necessarily required to be sent with every offer. Taylor, if you want to follow up on that. We haven't had that.
Yeah, I mean, the understanding who agents represent form is really only needed if you're working with an unrepresented party, which explains to that unrepresented person that you, the agent, you do not represent them. You have no duty of confidentiality to them. So yeah, the only time you need that is when you're working with an unrepresented party. If both the seller and buyer are represented, no need for the form.
Katie's question, cross-outs happen all the time. What is the alternative? Don't cross out. 2, get a lawyer to do the writing. Or 3, the parties themselves can take pen to paper. And I would have that in writing that they're the ones who did it, because you don't want to get in trouble after the fact. But yes, the Maryland Realtor forms, literally when you go to our website, they state that they are copyrighted and that they should not be altered in any way. Can you charge pet rent for service animals? No.
Or assistance animals.
Or assistance animals.
Right. You can't charge, well, let's just clarify, you can't charge any financial penalty, whether you call it pet rent, pet deposit, any financial penalty to somebody who has an assistance animal or a service animal.
Can clients alter the forms or write addenda? They should not be altering the forms, but if they want to write their own addenda, I've seen that happen where they've written stuff. That's up to them. If they'd like to submit, it's their choice. I would, if I were an agent, put in writing that unless they're an attorney, you would highly suggest that an attorney write it for them. Make sure it's legally correct and clear. Just because they write it doesn't mean the other side gets to sign it.
I see Rosaline's question. We can't write any addenda. Why then are the blank ones provided? Well, first, we as Maryland Realtors, we do not provide blank addendums. And second, agents you can write factual information. For example, if the party, which you could use a different form for this, but if the parties wanted to agree to change the settlement date, for example, that's a factual change to the contract. But anything outside of just a simple factual change, where if you're an agent and you're writing an addendum and you are changing the liability from one party to the other, or that's when you're going to get into that area of the unauthorized practice of law, which can get you in trouble for violating your code of ethics.
We have a good juicy question. Are brokerage agreements extended when there is a post-occupancy settlement agreement in place? The answer is no. It's post-settlement. If your client does not want to sign a certain document, or I guess as part of an offer, well, then it's a counter offer at that point. If they don't wish to accept part of an offer and it's going back and forth, it's a counter offer. Sorry, the questions are coming in. I'll let Kelly answer when the webinar will be available. I think probably by Monday, if not tomorrow, if you want to show the rest of your office or your teammates.
Yep, correct. It should be shared the latest by Monday afternoon.
Can a seller require an EMD to be non-refundable? That's possible. There's nothing legally prohibiting it, but an attorney or a broker should look to see how that should be written. Is there a proper way to, I just lost the question, to write an inspection addenda with the right to walk away if that is the wish of both parties? Taylor, I'll let you take that one since you're on forms.
Sorry, yeah, where was that one?
It was Vance's question. Is there a proper way to include inspections for information only with right to walk away if that is the wish of both parties?
So, I mean, we provide the forms are in their current state because of the forms committee. So our inspection addendum, you know, the rights of the parties are outlined in this inspection addendum. If the parties want to come to some other type of agreement where these inspections are for informational purposes only, I would not use our property inspections addendum because that's not what it states. If the parties wanted a separate agreement like that, they should be encouraged to contact an attorney and have an attorney draft that type of a language. Now, getting kind of towards your question, our inspection addendum does allow the buyer, after doing inspections, to freely terminate and walk away from the contract without stating a reason. So I think that does, unless I misunderstood your question, does accomplish what your client wanted to do.
This one was a good one. If the last person to sign does not designate a date of contract acceptance, do we not yet have a contract? Should every party initial the DOCA, date of contract acceptance? Are we not under contract until all parties initial the DOCA? I would say you probably are still under contract if all the documents that are needed to be signed between buyer and seller that indicate the meeting of the minds are fully initialed and signed and have been received by the last party to get those documents so that they know, yep, we now have a contract. The recommendation is that person, that party, should then put the date on which they received the last full packet that makes the contract and put that date and then send it to the other side to confirm, hey, I received it today. I'm putting today's date down. Here's the date. A lot of times we see blank ones, which is not a good thing. If you're concerned that everybody's under contract and somehow that was left blank, go back to the other agent and say, I just want to clarify that we're in agreement that this is the date, because this is when my client received the packet from you back, that it's signed, sealed, and delivered.
See a question from Dale King. It says, please provide clarification on time is of the essence. So time is of the essence. It is stated at the very top of our contract of sale. And it means that if the parties agree to a deadline or a time frame, then they are held to that deadline or time frame. So if the buyer has 30 days to secure financing, they are held to that 30-day timeline. And generally, if a party fails to meet a timeline or fails to meet a deadline, then they would likely be in default. There can be exceptions, but that's what time is of the essence means. It essentially means if there's a date that the parties agree on that X needs to happen, that needs to happen by that date.
Tony's question, what happened to the provision where an agent can make changes that are normal or necessary in their market? I have been in Maryland Realtors for 20 years, and I do not recall that provision in the Maryland forms. Do you remember it at all, Taylor?
No. No, I've
So
never
I don't know if
seen
that's in from some other form or jurisdiction. Let's see. Circling back to post-occupancy agreement. If brokerage agreements end at settlement, then the buyer designee or seller designee should not be the list agent or the buyer agent. Yes? Probably.
Right. And this is, I think actually, Clara, you touched on this on the slides. If your client, well, now past client, this is post-settlement, if they are asking you to do things, asking for your help, you should talk to your broker. And your broker will give you guidance whether you should be doing XYZ or you should not. So yes, reach out to your broker. Anything post-settlement, that's the best first stop for you.
Then anonymous, in regard to the inspection question and confusion regarding the G-car inspection, the right to void and right to negotiate, and you can select, can we just offer the right to void on more contracts? Well, that'll have to be a suggestion to the forms committee, upcoming new committee that comes in, and see if they want to speak to that at all.
Right. Yeah, it's right.
If there's one here. If an agent has the buyer and seller and both agree to dual agency, can the broker pay a referral fee out of the side not handled by that agent? I'm not quite sure what you mean exactly, because in dual agency, you must have 3 live people, a broker, a listing agent, and a buyer agent. So I'm not sure why there would be a referral fee not handled by that agent, because there should be more than one. So feel free to call the legal hotline for clarification. Oh, Taylor, here's one for you. Hard money lender has no financial contingency form. Is it okay to cross out conventional financing contingency form and use it for contingency?
Okay to cross conventional financing contingency form and use it for contingency.
Oops.
I don't think I totally understand. Is it okay to cross conventional financial contingency form and use it for contingency in hard money lender? I'd have to look exactly what the conventional financing addendum states. I would imagine the answer would be no, but I'd have to review the form.
All right, we have a couple of repeat questions.
Can you require that offers be written on Maryland Realtor forms rather than PG car or G car? Yeah, Clea, what are your thoughts on that? I mean, as a former
Well,
broker.
I have to tell you, sometimes I've seen local jurisdiction forms used in the wrong jurisdiction. So the Maryland Realtor forms are all encompassing. They can be used throughout the state of Maryland. So if you're using local forms, make sure they're appropriate. And I'll defer to those local associations who created those forms, and why they need to or can be used in those jurisdictions versus just the Maryland forms.
Zandra said, how do we officially make suggestions to the forums committee? So really, it's just a matter of getting in contact with us. So you could call into our legal hotline, write into our legal hotline, call our office, email any one of our attorneys, and all of our information is on our website to make a suggestion.
And then I'll take this as the last question. Buyer wants to submit an offer with appraisal waived and they are getting conventional financing. The attorney should draft the language for waiving the appraisal, but what should be done about appraisal language in the conventional financing addendum if we can't strike language? Ask the attorney to rewrite that as well, or an addendum for that client. And then following up for a previous question, if an attorney writes an addendum or information in the contract, how does that protect realtors? Well, just put it in writing that your client understands that they've hired an attorney to write certain terms of that offer or counter offer, and that they were aware that you had the Maryland Realtors and chose to speak to an attorney instead. Right. Well, I think those are all the pending questions. So we appreciate your time and your effort to be here this afternoon. I hope you've all found it useful and learned something. Please keep us in mind when you do have questions. We always say on the legal hotline and through our classes, we cannot review your documents for you. And if you have questions, you should definitely speak to your team lead, office or branch manager, or broker first, because they are your first line of defense. They are able to look at your documents and they do your compliance, and they should be intricately involved in all your deals and your clients, so they know exactly what's going on. So feel free to call us when they're not able to answer questions or you're not able to get a hold of them, but we're here to assist you and make sure you're doing everything that you can to assist your clients and learn as much as possible. Thank you again to everybody who attended. Thank you to the staff who came on board to assist us on this. And if there are no further questions, I bid you all a wonderful afternoon. Thank you.